There is a famous adage, generally we say that the end justifies the means. When the means are good, end is automatically, it becomes good. So, the end justifies the means. Supposing the goal may be quite lawful, but the means with which you have obtained the goal, then the goal also becomes completely tarnished and the goal also becomes tainted. So the means that you adopt must be lawful means. In this particular topic, we should remember Section 23 of the Contract Act. Section 23 of the Contract Act says that anything is lawful provided the object and means that are employed are considered to be lawful and it is not forbidden. So, you find unlawful agreements have been classified in my chart under 3 heads. There are certain things which are forbidden by law, that is illegal. Secondly, it is immoral. And thirdly, it is opposed to public policy. So that is why the section is very specific in this regard, which says that what consideration and objects are lawful and what not. The consideration or object of an agreement is lawful unless it is forbidden by law or is of such a nature that if permitted it would defeat the provisions of any law or is fraudulent or involves or implies injury to the person or property of another and the court regards it as immoral or opposed to public policy. So, that is why I have actually classified them. A contract is unlawful because it is illegal. It is opposed to common law or statute. Then the second one is from the point of view of immoral agreements, where there is an agreement which has got for its consideration future illicit cohabitation and separation between husband and wife. And as regards public policy, when it is opposed to common happiness or common harmony or common good, then we say it is not good for the country, it is not good for the society. Waging war against a nation or making transactions for the purpose of disturbing the harmony of the nation, harmony among people, these types of transactions emerging out of any type of agreements are prohibited under law. So generally you understand in that way. Now let us now try to explain each segment specifically. Now, a contract is said to be unlawful when it has got for its object unlawful goal. When it is considered to be unlawful end, then the agreement, much less the contract, becomes unlawful. So, now the unlawful agreements have got to be viewed from the point of view of common law. Now, what is common law? Common law says anything that is done by people in society must be good for the society. That is why even our constitution is considered to be based on welfare of the people. Welfare of the people must be given primary importance. So when it is opposed to common law, when do you say any transaction emerging out of an agreement is said to be lawful or unlawful? When does it become unlawful? When any agreement which has been entered into for the purpose of evading tax, evading revenue to the state, evading revenue to the nation. So, anything which emerges out of any agreement pertaining to a transaction must actually protect the revenue that is arising for the benefit of the state. So, that is why any type of agreement by way of tax evasion is considered to be unlawful. Unless, you see, tax planning is different. Tax evasion is different. Therefore, any type of tax planning within the framework of law is permitted and it is in accordance with law. But if you make an agreement for the purpose of evading tax, it is considered to be unlawful. So, the next important thing is, opposed to statute, if you violate any law, whether it is personal law or whether it is public law or private law, any law, if you violate or if you act in contraventions of the provisions of law, well, that is also considered to be unlawful. So, from the point of view of protection of revenue, I told you Bikani Bai versus Hirala. That is a case where state government gave authority to a particular person who has taken on contract the maintenance of the road system. So, a bridge, in that bridge, he was given license to collect toll. Toll money means that is the money which has to be paid to the person who maintains that bridge for the purpose of keeping the bridge intact and in order. So, this person was given, that too they actually conduct the collection right of toll money by conducting an auction. Likewise, in stations, in railway stations, you will find parking spaces that are actually sold by auction. The collecting authority is given by way of license, and it is conducted by way of auction, and the entire amount is collected from the bidder, and he is allowed to actually enjoy the license for a period of 1 year, and he has got to collect the money from all the vehicles that are parked in the parking space. So, this is the type of toll money. Like that, they gave this right to collect the toll money, whoever happened to use that bridge. It so happened that this contractor who has taken the license in his name, he has actually given the right by way of delegation to another person. He has actually wanted other person to be his subtenant and collect the toll. So far as the government is concerned, they are not bothered. They have already collected the money that is due and payable in respect to the bridge for which the right has been given to collect the toll money. But the auctioneer has already paid that money to the government. Or there may be arrangement, he has got to pay every month a stipulated sum of money. So like that he has paid, and whosoever who collects it, in fact, the very same person to whom authority has been given to collect toll, he may employ a person. Instead of calling the employee, you may call him as a sublessee. So, this is the way in which he has entered into a contract. And as I told you, this sublessee never paid the money which he collected from the vehicles which happened to pass through the bridge for a certain period. Thereupon, the head lessee, to whom authority was given by the government, he filed a suit against the sublessee. The sublessee contended, no, head lessee, you don't have a right to ask me because the government itself has permitted you to use this authority to collect toll provided you do not sublease it. There was a condition to that effect under the lease deed. But as I told you earlier, it is a matter between the head lessee and sublessee. If the sublessee has not paid the money, he cannot actually defend himself by saying, no, the government who are considered to be the owners of the bridge, they have not granted you permission to sublease it. It is for the government to question, when I am actually letting you into possession and I am asking you to be my sublessee. You have got to collect everything and you are answerable to me. There is a privity of contract between the head lessee and sublessee. Where is the government role now here? Therefore, you cannot actually defend yourself by saying the government has not permitted you to sublease this transaction. No, it is not like that. So the court allowed the head lessee to file a suit against the sublessee and said the sublessee has got to pay the money that is due and payable. It is for the government to question. Government should actually question whom? Question the head lessee for having violated the condition under their agreement. So that is the matter, because so long as the government receives revenue, normally government does not interfere into all these matters. So there is Bikani Boy versus Hiralal, about which I told. But Debi Prasad, there is a particular case, that is case of Rupram versus Debi Prasad. In that particular case, a license was given to extract toddy from the toddy trees in a particular toddy, the coconut garden or palmyra garden. From there they used to extract this what you call is alcohol or this liquid, and ferment it and then convert it into drink and then sell it. So government gave license for this for a set of people to extract toddy from the trees. And what happened, this license that was given to a particular person, he actually sold that right to some other person and permitted him to extract toddy. Thereupon the revenue authorities questioned, how is it that, see, lot of difference between lease and license. License is an authority, lease is a right. There is a lot of difference between right and authority. Right gives you authority, but here only authority only to a person concerned. Not it's a right that can be assigned or it can be subleased. So here the license has been, sometimes actual user's license. Actual user's license is given only for the person who has got the necessary infrastructure and who has got who is conversant with the technical know-how, and he has got the enough financial resources and place and all that. They insist, see, for the purpose of granting any license. So in this case, Abkari license under the Abkari Act, when a person was given license to extract toddy, he actually sold that license. The government questioned, now you cannot do it because it is opposed to law. So any license, actual user's license, for example, if any person who has got to import any goods under the Sea Customs Act, he cannot actually sell it otherwise than what is provided under law. So actual user, it is only for the person who intends to use it, for whom only the license is given. So that is why even in pharmaceutical shops, you find the trained compounder, who one should have actually passed the pharmaceutical examination and all that. It is not left open to any quack to come and act as a compounder. A compounder means he should be a qualified compounder. A doctor must be a qualified doctor. So these are all things which he cannot assign it or which he cannot sell it to any other person. So that is opposed to statute. So it is unlawful from the point of view of common law. Then from the point of view of common law, anything which is considered to be detrimental to society is not permitted. For example, gamble. Sir, in what way gamble? Gambling is easy way of making money. See, wagering agreement. Wagering agreement, wager means what? Wager is nothing but a chance. A gamble. See, a game which has got for its stake chance. See, playing a game of dice is a game which depends on chance. So, wager is nothing but a particular agreement which has been entered among parties depending upon occurrence of an event of which parties are uncertain about that event which is uncertain. So, the difference between wagering contract and insurance contract we are going to speak. Insurance contract is a contingent contract. Contingent contract is a contract where the happening or non-happening of an event is uncertain, about which parties are certain. Parties are certain about uncertainty with regard to contingent contract or insurance contract. They are certain that accident may happen. If accident happens, this is the way in which the money has got to be reimbursed. So that is what is known as parties to the contract are certain about uncertainty. But so far as wager is concerned, it is a chance. Parties are uncertain about an uncertain event. Not only the event is certain, parties are also uncertain about it. So, speculation. So, you have got a wagering contract. Wagering contract is a contract, the happening of an event which is uncertain, about which parties are also uncertain. Wager is either you win or lose. It is a game of dice. But however, there are certain contracts which are allowed, wagering contract. For example, the horse race. You see, normally there is horse race there, but this horse race is which horse will win, which horse will not win, we do not know. But it has become a sort of game and people enjoy it. But the government is benefited because the yield which they get, that is, the profit which they get from out of conducting these games, which are considered to be a gamble, if they are able to make use of it for the purpose of uplifting the poor. Likewise, lottery tickets. So these are all matters which are considered to be beneficial to the people who are at the lowest ebb of the society. For the purpose of upliftment of the poor people, these things are conducted, and the government has got license to conduct these gamble. What you call as gamble is considered to be a source of revenue from out of which the government is able to use these proceeds for some beneficial purpose for uplifting the poor people. So that you must understand. Then the next thing is, whatever you call may not be a gamble. In fact, see that whether it is a gamble or not, it depends upon the facts and circumstances of the case. In RMDC versus State of Bombay, in that particular case, they used to give the answer for which a question has got to be given by you. The answer will be given and you have got to give the question. For example, they will give an answer which is very, very misleading. For example, they give the answer as 8. Then what is the question? Question you have got to frame. 4 plus 4, you have got to put that question. Or 6 plus 2. Both these things will be available. 5 plus 3, 8 is the answer. You have got to select the question. You can select any question you like, any question in the manner in which it occurs to your mind. You can frame the question, but the answer must be 8. The government, the party who are conducting the competition, they have got the answer and you have got to select the question. Question may actually vary and every question may be also found to be fit. So, but the question which you prepare must actually suit the answer that has already been questioned. The question which the setter has actually prepared, that it must tally with that particular question, then only you will be. Even these, some of the programs which they are conducting, that also seems to be a gamble. See, a gamble is where you immediately make a person rich. So, easy way of making money, you become rich by answering certain questions, of which there may be 2 answers or 2 or more answers. And whichever answer suits the answer prepared by the producer of that program, then that particular person who selected the question, he will be given the prize. So, this is nothing but a gamble. So, gamble is, but if it is meant for uplifting the poor, government is actually especially authorizing certain projects which could be conducted, though it is a gamble. But the question came up for consideration. State of Hyderabad versus Satyanarayana. In that particular case, an interesting question was actually taken for discussion. Playing rummy, see, playing cards, whether it is a game of luck or is it a gamble, should it be prohibited? See, people actually play cards, But the court has distinguished cases where gambling plays a predominant role. But there are certain cases where skill and dexterity is used. For example, in the game of rummy, in playing rummy, a person must be able to calculate intelligently what card is being dropped and what card is actually taken up. So, any co-players who happen to play with the main player, they will be keeping a vigilant watch what cards are being dropped and what cards are being taken by him. So, they will intelligently plan according to which they will actually adjust their game. So, here they will play the game according to the manner in which the other person is picking up cards. So, this is a game of intelligence and one has got to use skill. Likewise, playing the game of billiards. See, when a person wants to play billiards means he must hit a ball. That ball must be able to hit the center ball, which is a red ball, and then that ball must be able to push another white ball and it should actually fall into the socket. You know, that is a game of dexterity. Even shooting, you must be able to aim properly, otherwise you will not shoot. It will misfire somewhere. So, here, any skill, any game which has got, for children, you actually give a sort of a sketch and in which they are asked to color the sketch, and then whichever child is able to paint it very nicely, that is a game of skill where you are testing the skill and the dexterity of a particular child to draw and to just draw the sketch and paint the picture. So, that is wherever you have a game for promoting the skill, that is not a gamble. So, in state of Hyderabad versus Satyaranama, the court held wherever any game is played which makes use of skill and dexterity, that will not be considered to be a gamble. So, gambling means chance. See, if any chance is there, then that is considered to be a wager. So, wagering agreement means an agreement which depends upon the occurrence of a chance. So, where there is no chance, it is not a wager. For example, chit fund. See, there are Appavu's case. So, in that particular case, running chit funds, Appavu versus Kamachi, if I remember correct, that is a particular case. Chit fund, you know, everybody must be knowing. Supposing you are actually a member of a chit fund. See, what they do is, every month they conduct a lot. For example, I am explaining you so that some of you may not be aware of the chit fund transaction. Supposing everybody will be asked to 10 persons will be asked to contribute 10 rupees. So that means 100 rupees. This 100 rupees is collected this month. Then they conduct the auction. So whoever wants to take this money for a lesser sum, if any person bids this 100 rupee chit for 80 rupees, then the chit is actually given to him, that offer to take that money by way of loan. So, next time onwards he has got to repay the loan, not that he will be given it as a gift. He has got to repay the loan. How much? He has got to repay 100 rupees. The 20 rupees that has been deducted from out of his pocket when he has bid for 100 rupee chit for 80 rupees, that 20 rupees is distributed among the 10 people. That means 2 rupees. So, any person who has got to, next time when he has got to pay 10 rupees, he will not pay 10 rupees, but he will pay only 8 rupees. So, like even that person who has taken the auction by bid. Likewise, this is considered to be a scheme which is based on some reason. It is not a gamble. Whoever bids it, the auction is also for the benefit of the particular organization which conducts the chit fund. That is why Sriram chit fund, so many Sudarshan chit fund, so many chit funds have become very popular. But at the same time, it helps the person who wants to money immediately, and he can repay it by equal installment after deducting what you call it as a accrual of benefit. The 20 rupees which has been deducted, that is being distributed for the next month, it is given as a sort of a incentive to those people. So this is what is known as a scheme where there is no gamble. You get back your money. Likewise, the system of conducting prize scheme where blankets are sold. See, if you are able to sell coupons, 10 coupons, you will be able to get back you will be able to get a vessel, good vessel like that. They are all, wherever you get money's worth, it is not a gamble. But mutual poor people association versus Topa Naidu, that was a particular case in which the institution, philanthropic institution, collected lot of contributions from the public in order to provide assistance to the poor people in that society, in that particular place. Then what happened? The money that was collected with good intention of mobilizing the money for maintenance of the poor is quite good. But what happened? The money that was collected was given by way of loan. Then the loan, who should be given loan? There was a scuffle among those people who happened to be members. Then they used to conduct a lot or a chit. Whosoever, the chit will actually be put under lot, and then whosoever picks up that particular chit, whosoever's name, in anybody's name is actually lifted from that particular chits, then he will be given the facility to enjoy the loan. So this was considered to be a gamble. The purpose for which money has been mobilized is for helping the poor. But these people, the amount that was actually collected, they temporarily, no doubt it was ultimately it was spent only for the public, but temporarily they actually made use of this money by way of loan. That was considered to be a sort of gamble. So wagering, now what is the difference between a wagering contract and insurance contract? Now at the outset, insurance contract is based on indemnity. Indemnity means any person who has actually suffered a loss, to make good the loss, you actually enter into an agreement with the insurance company. You will say, my house has been insured, my vehicle has been insured, third party insurance. If anything is happening to a third party who comes and dashes against your vehicle, then if that fellow sustains any injury, the insurance company will actually make use of the money for giving medical treatment, and he will be reimbursed if any loss that has happened. So, this is what is known as, it is essentially based on contract of indemnity. But whereas a wager, it is not a contract of indemnity. It is either a gain or it is a loss. Then, insurance contract, there is what is known as science of actuary. The premium amount is fixed on scientific principle. In wager, there is no scientific principle at all. It is only a speculation. It is only an art of game, chance. There is no such scientific analysis, and there is no science of actuary. Then, in wagering contract, there is no interest among the parties with regard to the subject matter or event. But in insurance contract, the person who insures the object or the property has an insurable interest. Unless he has got an insurable interest, the insurance company will not insure that particular property. If you do not happen to be a owner of a particular property, they will not insure. So you must be the owner. There must be an insurable interest between the subject and the object. But whereas in wagering contract, there is no such interest. It is only a question of making profit out of this gamble that makes people to enter into such agreement. That is it. Then the next point with regard to wager is either it results in loss or gain. But in the case of insurance contract, it is essentially based on contract of indemnity, making good the loss. Then the last point of difference is, in insurance contract, good faith is the rock bottom of the contract. Good faith, that is why we call it as Ubarime Fide contract. It is Ubarime Fide contract means utmost good faith. So humorously saying, somebody was asking whether it is a Upma Vade contract. No, it is a Ubarime Fide contract, means involving utmost good faith. The fiduciary relationship has got to prevail. Now, in the case of wager, there is no such thing as Ubarime Fide. There is utmost good faith is not at all there. It is only a speculation. It is only a aim of making profit. So, these are all by and large the differences between wagering agreement, wager, and insurance contract. If you bear this in mind, it is more than enough. So, these are all what is known as unlawful agreement. Now, not only as I told you, one thing I want to tell you. The end may be lawful, but the means which you adopt, if it is unlawful, the end also becomes tainted with illegality. Sir, give me some example. Sir, I am actually corrupting an official for getting some obligation from him, for getting some license. You should get license only by properly paying the money, properly driving license, for example. Take for example, when do they give driving license? Driving license is given when you are able to satisfy the authorities that you can drive properly, that you can actually take reverse without any sort of difficulty and all that. You are able to turn this side, you are conversant with the traffic rules. On the other hand, if anybody obtains driving license by corrupting the officials and getting it, well, this is what is known as corruption. So that is why not only the agreement must be lawful, for a lawful object, for a lawful consideration. All agreements or contract, if they are made by free consent, by parties competent, for a lawful consideration and for a lawful object. Lawful consideration, not corruption. Corruption is not a lawful consideration. Therefore, as I rightly told you at the beginning itself, I said, the end justifies the means. The means which you adopt must also be lawful. The end also must be lawful. If you remember this much, then it is enough for you to remember about unlawful agreement.